Hi, I'm Ed Bloom. I'm a principal at the law firm of Offit Kerman. Today I'm going to be talking with you about the purchase agreement for the acquisition of commercial real estate. The purchase agreement sets forth the pertinent terms and conditions to acquire real property. It should specify all important terms and conditions, allow for maximum flexibility to the purchaser, and minimize any surprises. Try to get the right that purchaser draft the contract to protect the purchaser. 10 things I want to talk about today. First, product description. Clearly describe what you're purchasing. If it's raw land, specify the square footage. If it's vacant, say so. If it's approved land, say so. Use addresses, tax ID numbers, legal descriptions. Attach a depiction of the property if possible. Remember, a picture is worth 1,000 words. Second, probably the most critical element in any purchase contract is the price, especially as far as the seller is concerned. Set forth the exact price. If it's vacant land, use dollars per square foot. So if the square footage is adjusted, the price is adjusted. Also consider seller financing. Third, the deposit. Most contracts will include a deposit. As the purchaser goes, try to minimize the amount of the deposit that's posted. Possibly a way to do that is a small amount is posted when the contract is signed, increased upon removal of contingencies such as the feasibility period. Fourth, feasibility period. That is probably outside of price the most important element in a purchase contract. A purchaser should have the full right to inspect the property to its satisfaction. The only restrictions that I like to see in a purchase agreement is subject to existing rights of tenants and possible indemnification for property damage. Include rights to perform environmental studies, physical examinations, and engineering inspections. Try to obtain from the seller copies of title, surveys, full copies of all the executed leases, environmental studies, and if possible, an appraisal. At the end of the feasibility period, the purchaser should have a right to walk away and obtain the prompt refund for any reason or no reason at all. Purchaser needs to be satisfied with the property. Fifth, representations and warranties. Every contract has them. The seller owns the property, the purchaser is buying it. It's really dependent on those reps and warranties to give it the comfort level in what it is buying. At a minimum, the seller should represent title. The title is good of record, marketable, insurable at standard rates. Also, include sellers of good standing. The property has access from the public right-of-way. There's no pending litigation. There's no seller bankruptcy, either with its entities or the individuals who own those entities. No pending condemnation. Attach full copies of all the leases, and there are no known defaults, amendments that are not attached, no known environmental hazards with the property, and no known property defects if possible. Sixth, tenant estoppels. At the time of closing, there should be an obligation of tenants to provide tenant estoppels. You should get that from all or at least the major tenants at the property. Those estoppels should provide that the lease is attached to the full copies, there are no amendments, there are no defaults, and there's no prepayment of rent. Seventh, closing. That is when it all comes together. Specify the closing date. There's no mechanism in the contract to determine the final closing date. You may not have an enforceable contract. Otherwise, you may have all heard the term, the rule against perpetuities. Purchaser should be able to select the exact date of closing within a range, as well as the agent conducting the closing. Title to property can be transferred most commonly by special warranty deed. In certain jurisdictions, such as Virginia, which protects the purchaser the most, a general warranty deed with English covenants of title. Eighth, in connection with closing, there are lots of costs involved. Who pays those costs? Most contracts evenly split transfer and recordation taxes. In area like Maryland, it can be 2.5%. In DC, almost 3% of the purchase price. That's a lot of money. Make sure that's negotiated up front. If you're transferring raw land in Maryland, there may be an agricultural tax, which is high, to be paid for by seller. Also, sellers should obtain a residency affidavit. Ninth, survivability. The reps and warranties that I discussed earlier that are being provided by seller, you want to have teeth to them. If they need to survive the closing. If they do not survive the closing, they're merged with the deed. 18 to 24 months should be the minimum to protect the purchaser. And 10th and finally, if there are any post-closing obligations, they should be detailed in writing and signed at the closing table. Some Post-closing obligations is possibly allocation of rents collected post-closing, who pays special tax assessments. Seller should be obligated to provide notices of the sale to any existing tenants, and seller should also be obligated to promptly deliver to purchaser any notices received after closing. Good luck with your property search. Thank you.